Welcome to OREIA's third Sunday sit down, which is actually a monthly session where we talk about some uh, topic involving real estate or legislation or the market that is too timely and important to wait all the way until the OREIA National Summit that happens every November. And we happen to be at a time right now where we've got this new Ohio wholesaling law that is going into effect in just a couple of weeks that we wanted to make sure that everybody was up to date on. I noticed we have a lot of out of state investors on the line. I recognize some folks from Georgia and Tennessee and California. And I think some of you are probably here because you buy from wholesalers in Ohio, which is a good thing, or because you want to long distance wholesale in Ohio, or maybe, oh, in Colorado and Chicago. Maybe it's because it has been suggested that rather than sit around and have your state make one of the more typical wholesaling laws, and by more typical, I mean they simply lock it down to where you must have a real estate license in order to wholesale properties. You can maybe take a group of your friends to your state legislature and say, hey, we think that something needs to be done to help protect consumers in our state, and here's a suggested law. And you can show them the Ohio law because it is a really good law, particularly relative to those of you who live in states where it is, in fact, impossible to wholesale properties unless you go through the entire process of getting and keeping a real estate license. I wanted to remind everybody that this is what you're about to hear here is not legal advice. One of the things we heard over and over as we talked to the Department of Commerce and talked to the General's office is they don't give legal advice. We shouldn't give legal advice. Anybody who's got an issue that they don't fully understand the answer to should probably get a lawyer. Also, we're talking about what we know as of right now. You know that the laws can change, the enforcement or interpretations can change, and as that happens, we will have updates. But if you have a specific situation, you should get advice from a licensed attorney.
Hey.
Let's bring Ronnie front and center because we want to start with why it is that OREIA was so involved in this law from really before it was even proposed. And Ronnie has been the point person up at our lobbying firm GPG who brought us in on this so early, like it had just that minute been started to be floating around when we got to have some input on this. So, Ronnie, can you talk to us? I see
Well,
Ronnie,
Ronnie
but
is
I can't
muted.
hear
Ronnie
him.
Romito.
Yeah, I'm going to
There
hit
we
the
There he
go.
is. All
Thank
right. Sorry
you.
about that.
Um,
okay.
yeah, so I'm Ronnie Romito with Governmental Policy Group. We're an independent lobbying firm. We represent OREIA at the State House in Columbus. And the key thing with this legislation, like Vena said, OREIA's government affairs team is always active at the State House. Currently, we're tracking and monitoring dozens of bills. I think there's close to 10 right now that we're active on that directly impact the real estate investment industry kind of writ large. Um, so looking back with 155, that's the wholesaling bill that just passed. We were very active from the get-go in fighting to keep this legislation to a workable dynamic. There were a lot of proposals out there that really would have hampered the industry when it came to wholesaling, and OREIA was key in being vocal about that, talking with the legislators, talking with the other interested parties, making it clear how what it is that we do, everything that Vena is going to talk about tonight. Um, could be detrimentally impacted, making sure they are aware of those concerns. So that was going back to, like Vena said, before the bill was introduced. It started out in the previous General Assembly a couple years ago. There were some egregious pieces even in that introduction. We worked through it during that cycle. The bill was introduced this year in both chambers, and all the way up until pretty much the last minute, we were able to get a change in with the disclosure language, really to make it palatable, make sure that, like I said, that it functions. And so this is something that OREIA does on the regular all of the time, all the legislation, property taxes, anything that impacts the industry. OREIA is on it, and we work a lot with your team and your voices locally, kind of move on up to the larger statewide organization. So I think that it'd be fair to say, Vena, communicate within your groups, make sure that folks know the issues that you're seeing. I also should give some kudos to you all too, because I know you have one of the more robust kind of active streams when we put out a call for action. Deborah has some numbers on that, I think. You're very responsive. And so that also is helpful, echoing the message that OREIA is giving to the legislators out there on all of this legislation. I do also want to make a plug too, not just for the statewide organization, but also the PAC. The PAC's important as well. It helps us to ensure that we're supporting like-minded legislators who come in, who understand the industry. And I know that that's an important component too for you all to understand those dynamics kind of play at hand. So supporting the larger statewide organization, the PAC as well, are important in the things that we do.
Yes. A lot of people who they're only the only time they ever touch the organization is when we have that annual convention. They think the organization is the convention. They say, "Oh, I'm going to OREIA." No, you're not. OREIA is a 365-day-a-year lobbying organization, and that convention is where we get the money to do all of this. So the really important work is that we are the only organization in Ohio that represents small investors, which would include wholesalers, retailers, smaller owners of rental properties, short-term rental owners, folks like that. So we have been expecting this legislation for over a decade. We've been talking about it and saying, yeah, it's going to come here because it has come every place else. The reason we were expecting it is the same reason that it has already passed in way worse forms in a lot of the country. A lot of times when I talk to folks who are subject to these wholesaling laws, they say, "Oh, well, it's the realtors. The realtors are jealous of us. The realtors don't want us to be wholesalers because then we are taking part of their business," right? There's this whole idea that it's all about the realtors. And Ronnie, the realtors were actually kind of on our side on this one, as I recall. Or let me say they didn't object to what we were putting out there. Wait, I gotta get you on mute again, Ronnie. Okay, or maybe you can't do that. So yeah, what we kept hearing was that, and this was from the lawmakers, this was from the people who were trying to, get some version of this passed. And we were hearing things like, "Oh my gosh, there's a 70-year-old woman in my district who somebody bought her house for $150,000 and sold it for $170,000 the next week, and that's equity stripping." And we heard, in my district, we see wholesalers putting properties under contract and then listing them for $50,000 more than the contract price on the MLS. And oh my gosh, the thing that somebody is out there teaching, where as soon as you put a property under contract, you go file a memorandum and affidavit at the courthouse to cloud the title. Oh gosh, they hate that. both the legislators and the regulators absolutely hate that, especially when that cloud is still hanging on the title 2 years after you were unable to close because you didn't sell the deal. And we heard a bit of, sellers who thought the wholesaler was working for them. In other words, I talked to a person in my district, and they thought that this person who was coming to them was a real estate agent, and it turned out they weren't a real estate agent. The early drafts did require a license to wholesale, and it did a whole bunch of other really strange things, like you couldn't use a power of attorney to, and we understand where that came from, because again, there's people out there teaching, don't assign the contract, get a power of attorney, and then you can assign your own contract, which is, don't do that, folks. Please don't do that. So they just overreacted and said nobody can use a power of attorney to list or sell a property, which is like, that's tough when, like, you have an elderly parent who wants you to help them sell their property, or your spouse is who owns the house is deployed overseas. So anyway, it was OREIA's outcome that changed. It was OREIA's involvement that changed that outcome. And the result is that contract assignments are still legal in Ohio, but there is a strict disclosure. So let me walk through where all this lives, so that if you want to actually look it up and read it for yourself, you can do that. And then we will get into what it says. And this is going to be a pretty deep dive, ladies and gentlemen, because listen, I am a multi-year, like 30-year wholesaler. I've probably done 1,500 wholesale deals in my lifetime. And the thing that I have learned over the years is that if you're going to make serious money in the wholesaling business, you need to take it seriously. It can't be this, I'm going to play it fast and loose, and whatever I have to do to make a buck, I'm going to do to make it. If that's the way you act, well, if that's the way you act, you're the reason we have wholesale laws all over the place. So I'm hoping that in the next hour you will really understand what this law says and how you can comply with it. And also, maybe you do take the time to read some of this other stuff, because it doesn't just affect what you might think of as a typical wholesaler, which is a person without a real estate license who assigns contracts on real estate. It affects also, like it is written into the law that licensed agents can be disciplined by the Department of Commerce. So we've got the Attorney General on the one side and the Department of Commerce on the other side for not complying. There's a piece of the statute that says that brokers have to give earnest money back to the sellers if the sellers cancel their wholesale contract. And there's also Ohio Revised Code 1345, which is the law that's going to be used for enforcement. So here's the big high-level overview, okay? This law takes effect March 2nd. It applies to wholesalers of 1 to 4 unit residential property. We're actually going to break down some of these definitions, because up until this law passed, there was no such thing as a definition of wholesalers in Ohio. Like, literally, there was no legal definition, and now we have a legal definition. It requires that you do a standalone written disclosure, which we are going to both post in the chat. We've actually got the disclosure. We're going to post it in the chat, and we're also going to email it to you so that you can save it permanently in your forms and contracts file, so that you can always, always, always be using it, especially after March 2nd. The disclosure has to be given before, and by given, I mean presented and signed before you sign a binding contract. And binding contract is maybe bigger than you think. As I read this, I'm a wholesaler and I'm a licensed broker, but I am not an attorney. But as I read it, this law applies to subject to and lease option assignments, as well as standard wholesale assignments. This disclosure can't be buried, it can't be waived, and it can't be fixed after the fact. If you fail to comply, the seller has the automatic right to cancel your contract right up until it closes. Like literally, you can have the property under contract for 45 days. You can have a buyer sitting at the closing table. And because you did not make the disclosure, the seller can say, nope, change my mind, not selling to you. And when they do that, if there's any earnest money up, it goes to them. It goes to the seller. They canceled it, but the earnest money still goes to the seller, which means it could cost you your earnest money, whether you are the wholesaler who put it up or whether you're the buyer of a wholesale deal who might have put up that earnest money. Failure to comply can also trigger attorney general enforcement and or civil action by the sellers themselves. And as I said before, and we'll get a little into more detail about, it can lead to you getting disciplinary action as a licensee if you undertake certain acts. So let's break that down. So that was a lot. Let's go slow now. And Matt, if you can go ahead and put that disclosure into the chat so that folks can download it now if they are on their computers. All right. First definition. Residential 1 to 4 unit dwellings. So this disclosure requirement only applies to single family through 4 family properties. Now, don't get confused about that word residential. Okay, so residential, 1 family through 4 family. Do not get confused by the word residential and say, oh, well, if it's owned by, if it's being used as a rental property, if it's owned by another investor, then I don't have to make the disclosure. While you and I can have that argument about is it residential in like the Dodd-Frank sense, if it's owned by another investor, this law pretty clearly means any 1 to 4 family. But it does not include raw land. Anybody here into flipping land? That's a popular thing. As long as the land is unimproved with a dwelling, doesn't matter. It also doesn't include true apartment type units like 5+. It doesn't include commercial. If you were flipping a strip center, you would not need to do the disclosure. And it also does not include flipping mobile homes as long as, and you guys who do mobile homes will understand what I'm saying, and everybody else, you don't really need to understand if you're not into mobile homes. If the mobile home is in a park and it's not permanently affixed to the land and it's not titled as real estate, you can flip mobile homes without this disclosure, apparently. However, if the mobile home is affixed to the land and titled as real estate, you have to do the disclosure. Now, what's a wholesaler? Because, it says the law applies to wholesalers of residential 1 through 4 property. Well, it might seem really obvious to you, but I would argue that anybody who does a business-to-business transaction where you are finding deals that you think other investors would like to pay you a little more for than what you paid for them, you're a wholesaler. I mean, that's, like what's a fruit wholesaler? Somebody who goes out and sources oranges and marks them up a little bit and sells them to other businesses that then mark them up some more and sell them to deals with directly with the public, right? And I would say you're a wholesaler if you buy a property for $100,000 and sell it the next day without improving it to an investor for $110,000. However, the definition within this law is only around people who assign contracts. So a wholesaler is defined as a person or entity that enters into I said purchase contract on this slide, but I'm going to change that in a future slide because it doesn't actually, I don't think it's specific to purchase contracts. With the intent or expectation of receiving a fee or profit by assigning or novating the contract. Now they picked up on that word novation. That's a YouTube guru word that the way that the gurus use it is not actually the legal definition of novate, but if one of those people is your guru, you know what that is. You know what it is. You know what they mean when they say novate a contract. With the added thing that the wholesaler is not a person who's going to take legal title. That is an important definition right there. It specifically says in the law that it is someone who has an intent to receive a fee or profit, who assigns or novates the contract and does not take legal title. So what this means is the law, although it doesn't specifically say this, it a little bit says it by its silence. This applies to contract assignments. It does not apply to deals where you close the deal and then sell it. Expectation and intent. We had a lot of conversations about expectation and intent with the people writing the law, with the Department of Commerce over the years, and with the Attorney General's office, and with our own attorneys who say things like, how do you legislate intent exactly? How do you prove what somebody's intent was in retrospect? But in the law, it says that you don't actually have to assign the contract. You have to have a profit motive and intend to sign the contract. The fact that you failed to actually sign the contract does not mean you shouldn't have done that disclosure up front. So, I mean, that's pretty far reaching, right? Like, I guess what it says in the real world is if I put a house under contract and then I'm out there advertising that I've got that contract for sale, I'm putting it on my Facebook page, I've got it on Facebook Marketplace, I'm taking it to my OREIA group, I'm making a real attempt to sell that contract. The fact that I didn't actually sell it does not mean I should not have done the disclosure and that I would not potentially be penalized, because you guys got to understand this law is 100% about the disclosure. It is all disclosure. What you have to do is disclosure, and what you get punished for is not doing disclosure. Now, there are some exceptions where you can assign a contract, and if you didn't do disclosure, you didn't have to do the disclosure. And the middle one of these was one that OREIA kind of insisted on because it happens, right? The first one is if you assign the contract to your mom, your dad, your kid, your brother, your sister, blood relatives. Not a big deal to not do the assignment. I'm not sure who thought that up. I'm not sure who was like, well, what if I want to assign a contract to my mother? I don't know how often that actually happens. It's entities under common control was the one that we were very insistent on, because a lot of us who are full-time real estate investors, we have multiple entities, and we might put a property under contract in one entity and thinking, well, I'm gonna buy and hold it, so I'm gonna put it under contract in my rental entity. But then later on, as I'm looking at it and talking to the contractors, I'm like, man, this would be a great flip. This would be a great buy it and resell it kind of deal. So I can assign it now from my rental entity over to my flip entity, and I'm not going to get in trouble for not having made the disclosure, because it's like a me-to-me assignment, right? As long as there's, it's a subsidiary company or an affiliated company or some kind of common control. And again, commercial and non-residential properties, you don't have to, those are not covered assignments. You don't have to do the disclosures for them. Now, we do need to remember that disclaimer up front about how stuff changes and we're not attorneys and all that stuff. There are certain things that this law very clearly does not define. It does not define common control. It doesn't say well, if me and Scott Landers own a company together, and me and Scott Landers put a property under contract together, and then I'm like, I don't really want this, and Scott's like, I do, and I assign it to an entity that only Scott owns, was that a commonly controlled entity? It's not. The law is silent on that. I mean, I think we can probably go on the kind of common definition of that, which is like 50% or more controlled by the same people. The law doesn't explain how intent would be proven. I think probably because we don't see a lot of laws come out of the state or federal government that cover ESP, which is what you would have to know what my intent was when I put a property under contract. The problem is there's a difference between, okay, well, practically, you can't really tell what somebody's intent was, and the discretion of the folks who get to enforce this, right? So the silence in the law about anything is not protection for you. So when is the law triggered? It is triggered before you enter a binding contract that transfers an interest in residential real property. A binding contract that transfers an interest in residential real property. So if this whole time, as you've been hearing about this, you said, well, that's fine. I just won't use purchase contracts anymore. I'll use options. Now, the problem is an option is a binding contract, at least on one side, at least on the seller's side, that transfers an interest in residential real property. The disclosure timing is important. It says very specifically, you have to have this disclosure signed before you enter the contract. So I think in the real world, what it looks like if we're face to face with the seller is, hey, here's this disclosure that the state has every wholesaler give people. Sign this. Okay, now here's the contract that we've agreed to, sign that. I asked the question yesterday or I guess it was Friday on the Attorney General's, called with the Attorney General's office about what about an online workflow? Because, a lot of us, we don't necessarily go sit down in front of every seller anymore. We have stuff in DocuSign and whatnot, and we simply email it over to them. And I said, so are we going to email over the disclosure first and wait until we get it back before we send over the other stuff? Because in the real world, that's a pain in the butt. And also, I don't know about you guys, but when I'm wholesaling properties, I'm sometimes dealing with people who are like, yeah, I think my wife's got an email. You send it over there. I'll never check it, but like it's difficult enough to get the email received and signed that I don't think I necessarily want to get two different ones received and signed. So I asked the question about, could it just be like the first page? Because in the DocuSigns, usually it takes you through and, you sign or initial each page as it comes up. And they were like, look, the courts know about this stuff. The purpose is not to catch somebody because the disclosure came with the same packet of documents but got signed 10 seconds later. The purpose is to make sure that consumers understand what it is they are getting into. A late disclosure doesn't cure the violation. And that's a really tough thing about this law. If you realize on March the 3rd that the property you put under contract the day before should have had a disclosure in it, and you're like, oh, I want to do the right thing here. Let me go back to my seller and get this disclosure signed. That you still, the violation already happened. Signing it later doesn't undo the violation. So the only thing that I can think of is you would have to cancel the contract you signed yesterday. You'd have to get an official, like, I'm withdrawing this, and the seller is withdrawing it, and we have this new contract, and now let's get the disclosure signed and the new contract signed. It will not help you to call an assignment a novation. It will not help you to call it getting an equitable interest. It will not help you to call it a JV agreement. It will not help for you to call it an option. Any contract for the purchase of real estate that is entered with the intent to assign it is covered. So don't, I mean, one of the things that I just rail about all the time with real estate investors all over the country is that when these new laws get proposed, instead of going in and working with our legislators to try to explain what it is they are proposing to regulate, because I'm telling you, they often don't know. Ronnie and Scott will tell you that part of the conversation we had on with the Attorney General's office was just kind of getting their brains around what a contract assignment was. That's true. They why would they know? They're not real estate people, right? Instead of doing that, we sit around and we go, I'm smart enough to get around this. I'm just going to do it this other different way, and they can do whatever they want. They're not going to catch me. So our rights get eroded little bit by little bit by little bit by little bit by little bit. Because rather than stand up and say, wait, let's explain this business, let's explain what's good about it. I spent almost all of last year's day at the Capitol talking to legislators about the good that wholesalers do in the world, because they had never heard that story. They had never heard a story about how wholesalers actually helped people get rid of a hoarder house that they couldn't deal with. Aren't subject to assignment or subject to deals like there's this whole thing about, go out and put subject twos under contract and then assign that contract, which, by the way, we need to have a whole different discussion about that. But is that not a contract to acquire real estate? And is that on a contract that you entered with intent to assign it? I'm not a lawyer, but I think yes. So if you do subject to assignments, you are, in the state of Ohio, you are going to be subject to this law, or at least you're going to do it to be safe. What about lease option assignments? Haven't heard as much about those in the last 10 years as I have, really last 5 years as I have about subject to assignments, but those are a thing too. I lease your property with an option to buy it, and then I assign the lease and the option to buy. The option to buy is meant to convey a right to purchase a piece of real estate. I think you still have to do this disclosure if you're doing lease option assignments. So the core requirement, it's all about the disclosure. It's the heart of the matter. It's the failure to disclose that triggers everything else. And the disclosure has to be meaningful and in a particular form. Matt, this would be a good time to post that form again for folks who popped in late. It has to be a separate document. It has to be written in 12-point type and boldface. And part of what has to be written in the document is that the document has to be written in 12-point type and boldface. Half the document is explaining how the document has to be written. And it also has to be conspicuous, meaning that you can't bury it somewhere. Here's the big picture. Again, you can just read the disclosure that Matt's putting up, or that Deborah will email to you if you can't open it. The buyer is a wholesaler. That's one of the things that you have to say, although they gave very specific words about how you say this. The buyer does not represent the seller, because one of the things they kept hearing was that, oh, I thought he was my agent. He was trying to do the work for me, like he was trying to sell my house for me. You have to disclose that the contract can be assigned without consent, that you might profit from this assignment, that the price at which you are contracting could be below market value, and that the seller is encouraged to seek professional advice. Now, that last one, I was absolutely willing to die on that hill, because up until the last minute, what those words in that disclosure said were something like, the seller is encouraged to seek legal advice before entering into any contract with a wholesaler. And I was like, well, that is, first of all, I'm not actually sure you can pass a law that says that a business person has to tell somebody else that people need to be protected against you, but that's neither here nor there. It's it's meant to keep people from wanting to sign contracts with wholesalers, right? So when you look at the current language, and this was what we asked for, it says something like sellers encouraged to seek legal advice regarding any real estate transaction, including one involving a wholesaler. The language is much more, hey, it's just a good idea to, like, if you don't understand a contract, to have a lawyer look at it, than it is don't sell to this person. It then has to be signed and dated by you and signed and dated by the owner of record. And really, it should be like anybody you need to sign the deed should also be signing the purchase agreement, and therefore should also be signing this disclosure. So, I mean, that's not about the law. It's just about practicality. If if a brother and sister own the property and only the brother has signed the purchase agreement, you don't actually have a purchase agreement. You have a purchase agreement for his half of the house. So everybody who's going to have to sign that deed should be signing both the purchase agreement and also the disclosure. Remember, it has to be executed before the contract, executed meaning signed, of course, and an unsigned or late disclosure is no disclosure at all. The law specifically, explicitly forbids that you make this disclosure part of a bigger purchase contract. If you're thinking, well, what I'll do is I'll bury it in my already 7-page long purchase contract, which, by the way, is way too long. If you're working with civilian sellers, you should have a 1-page purchase contract. You can't just like make this clause number 78 of your purchase agreement. It has to be freestanding, separate. It can't be an addendum. It's got to be a separate document. You cannot have the seller waive his right to get the contract. You can't have any oral or written workaround to presenting this disclosure. So what happens if you don't? Well, potentially a whole bunch of stuff. Number one, the seller can cancel the purchase agreement before the closing with no penalty. You cannot do anything at that point to force the seller to sell to you. Your usual rights, which would include things like suing for specific performance or suing for damages, you lose all of that. You lose all of those rights. I would not be filing a memorandum and affidavit against the seller who canceled the contract because I didn't do my disclosure. I would not like the look of that in court. Any earnest money that is being held by, it would typically be a title company or an agent, gets dispersed to the seller. The seller's protections continue to exist no matter what kind of workaround you've tried to do with it, no matter what he signed, no matter what you've agreed to. These continue to exist. Now, I always think a really good way to keep yourself out of trouble in any kind of real estate deal is to think through all the ways that people could abuse something or do things wrong with it. And I just want to ask, and anybody can answer, do you see any way that fellow wholesalers could abuse this law where it regarded contracts that you had with people? You have a legitimate contract with a seller. As you know, very often another wholesaler will come along behind you and be talking to your same seller. Can you think of any way that if that other wholesaler knew this law well, they could be trying to snake your deal from you.
Yeah, they could say that this contract is illegal that you signed with the previous wholesaler because the disclosures are not in place, and then they can go on to contract and have them cancel the first one.
Yes, sir. And in fact, they can go way beyond that. They can say, listen, not only can you cancel this contract, you can keep all the earnest money they gave you. And also, you even have like an action in court where you could maybe get some more money for them, and I'll give you more money. That would never happen. There's no such thing as bad actors out in the market. Except obviously there are, or we would not have this daggone law to begin with. I've heard first person stories about wholesalers walking into members of my group's houses, like going to their rental houses, knocking on the door, getting invited in, and asking the tenant to file code violation complaints against the owner. I always say, well, you can't, sellers are either motivated or they're not. You cannot turn an unmotivated seller into a motivated seller, except maybe you can if you get the building department sicked on them. And the story I heard was they offered to pay the tenant $50 to do that. Those will be the same people who try to go around behind your back and find out whether or not you did the disclosure. And if you didn't, we'll try to lure your seller into going into contract with them.
Yeah.
Again, fixing it later does not fix it. The violation occurs at the time that you execute the contract. Later disclosure does not cure it. And good faith, like I didn't mean to rip anybody off, I just didn't know about the law, is not a defense. So, what do you do if you realize I did not do what I was supposed to do here? Well, again, you got two choices. You can go back, cancel the old contract, get a disclosure, and sign a new contract, or you can close the deal before you sell it. Instead of assigning the contract, you can get some private money, some transactional money, get the deal closed and sell it to your buyer, because this law only applies to contract assignments. Now, there's still that question of intent. Well, she intended to assign the contract. It's clear she intended to assign the contract because she was advertising that she was going to sign the contract, but then she realized she'd made a mistake and she turned around and double closed it instead. I don't know that you're going to get in a bunch of trouble for that. In the conversation with the folks from the Ohio Attorney General's office, they made it really clear that their concern was consumer protection. It was not jumping on people for ticky-tacky stuff. It was not going after, it wasn't going after folks who did this one time. And I'll explain what they said. They said they could take two routes of how they might enforce this. The enforcement, I mean, it says Attorney General. That's kind of scary. It sounds criminal. All the enforcement is really civil. It has to do with civil fines, court cases, investigations, trials. Again, the Consumer Sales Practices Act is the act that is going to determine what the penalties would be. What we heard from both the AG's office and the Department of Commerce was they're not going to be, at least at the moment, they are not planning on being out there looking for wholesalers who are doing wrong. This is going to be consumer complaint driven. And remember that these consumer complaints are probably not going to take the form of, I didn't get a disclosure. Like the consumer, that's the least of the consumer's problems. The consumer complaints that they're going to get are, I thought this person was an agent and it turned out they were listing my property for 50,000 more than they'd agreed to pay me, or I can't get out of this contract that somebody put me under because they wrote it in such a way that the the inspection of the property triggers the closing date. Let me say it in a much plainer way. I saw a contract from a wholesaler. This guy had already tied up my seller's property for like 5 months and had not been in contact with him for like 3 of that 5 months. And he really wanted to move on and sell it to me. And I looked at the contract, and what the contract said was closing will occur within 2 weeks of inspection by the buyer. He'd never inspected it. So the real argument there is because there was not a fixed date for this contract to close, then it wasn't really a contract. But the practical issue was the seller was basically going to have to go to court with this guy to prove that if the guy objected. So the consumer complaints that they are getting and are going to get are not going to be about the disclosure. It's going to be about something else. And then the disclosure is going to become, well, didn't they tell you that they weren't working for you? Didn't they tell you that they could make a profit? Well, no, they didn't. Okay, well, so there was no disclosure. Those complaints, by the way, are public record. The AG's office said that the first step would normally be what's called an informal dispute resolution. So if this is like a first-time thing, they have not heard your name before, it seems, like maybe you didn't know about the law, or they would reach out and contact you for this informal dispute resolution. They would request a response. They would try to work something out, if you will. They would try, because there's no way for you to fix it because you already broke the law and you can't unbreak it by going back and giving that. But they would try to work something out that made the seller happy and you happy. If they decide to do a full-on investigation, they have all sorts of tools at their fingertips, including subpoenaing you and your records, including sending you a cease and desist order saying, don't you dare wholesale anymore. They can do settlement negotiations, or they can enter into actual litigation against you. Wouldn't that be fun if the Attorney General of the state of Ohio decided to enter litigation against little old you? Wouldn't that be the funnest 2 years of your entire life? Let's avoid that, okay? Because the potential penalties here are actual damages. Now, again, I'm not an attorney. I don't know how you measure the actual damages of non-disclosure. I know there are sellers who do experience actual damages when wholesalers put their properties under contract and they can't close, and the seller ends up losing their house at a foreclosure sale. Like I could argue what the actual damages are in that case. I don't know what the actual damages are if I didn't get a disclosure that I should have gotten, but that's one of the potential penalties. You can end up paying restitution. You can get injunctions against you, and then the really fun thing is, according to this Consumer Protection Act, you could potentially be subject to a $25,000 fine per violation. And what's a violation? Back when the Department of Commerce was going after this as an unlicensed activity, they said out loud that a violation would be every day that you advertised a property that you had under contract, and for each different property could be considered a violation. These other things, so we're talking about the Attorney General being able to enforce this. You understand there's also a private cause of action here. The seller can take you to court and say, I had actual damages, I need restitution. I don't know that the court in that case is going to put an injunction on you. But the other thing that we have to be really careful of, how many of you guys have a real estate license? Just say I do in the chat if you have a real estate license. Because I do. Mark does, Alberto does, John does, Martha does, Tansy, Scott. Oh gosh, lots of you. Lots of you have real estate licenses. There's two ways that the Department of Commerce could still get involved in this. One of the things that was fascinating to me about this whole process is that generally anything involving real estate falls into the Department of Commerce's area of enforcement. And this is, even the Attorney General was like, we don't really understand why this came to be on our plate, because like the Consumer Protection Act doesn't really usually, it's not about real estate. Real estate transactions are handled by the Department of Commerce. So this goes two directions. Number one, if you are a licensed agent, you are still subject to doing this disclosure. So now you have two different disclosures to do, right? You've got to do the one that says, I'm an agent and I'm working for me, not for you. That's the typical agency disclosure. And then, of course, when you're working with the buyer, you say, well, you're saying the same thing. I'm working for, when you're buying the property, the disclosure says, I'm working for the buyer, me, not the seller, you. And when you're signing that contract, you are saying, I am working for the seller, me, not the buyer, you. And in addition to that, you got to comply with this law. The Attorney General can still come and get you over not doing it, but the Department of Commerce that regulates your license and whether that license is going to get suspended, revoked, etc., is also in charge of you as a licensee. So it's possible that you could have two separate complaints going on the same issue, and that the Attorney General could say, okay, we think you were legit and just don't do it again. And the Department of Commerce could say, yeah, we're suspending your license for a couple of months. So when we met with the Department of Commerce, I said, it appears to me that this law firmly establishes that in the state of Ohio, wholesaling is not an activity that requires a real estate license. And the ladies on the other side of the table objected to that characterization. I believe the word that they used was unconvinced. We're unconvinced that wholesaling is not an unlicensed brokerage activity. And then when I said, well, in what way is it? I got the same answer that I got when I talked to them 10 years ago, which is, well, it's hard to define and we know it when we see it. But I can tell you what some of the main issues are for them. You guys cannot be using any language in any of your marketing or discussions with people that sound like you are trying to represent them. We had a local wholesaler here, a big one too, who underwent a year-long investigation by the Department of Commerce for unlicensed activities, and it was over just a few words on his website. And the word said something like, fill out this form and tell us what you want. That's how we build buyers lists, right? As we find out what people want. And we will find it for you. Now, why does that sound like what an agent does? What agents do is they go and try to find the property that their buyer wants at the price that their buyer wants it, right? Is that what a wholesaler does? I mean, in my brain, what a wholesaler does is goes out and finds people with properties and problems and tries to create a deal that some buyer somewhere will probably want to give them some money to take over. They do not go find properties for particular buyers. So although you might think that's good marketing language, yeah, tell me what you want and I'll go find it for you. It sounds like you're acting like an agent. Another example of that sort of marketing language is let's get your house sold for you. When you're not in fact an agent, you're a wholesaler and you're gonna set yourself up as the buyer and then assign that contract. Big concern of theirs is people who advertise that they have properties for sale when what they have is contracts for sale. And we really police this in our two groups. We've got the free websites for wholesalers, and when wholesalers say, I have 123 Easy Street for sale, if we catch that it doesn't say it's a contract assignment, we make them take it down and put up that they don't have 123 Easy Street for sale. They have a contract to purchase 123 Easy Street for sale. Agents, a new thing that they brought up when we met with them, I guess it was last week, was that they said the number one complaint that they are getting is from agents, but not about wholesalers, about other agents who are listing contracts in the MLS as if they were properties. And I know that's being taught. I know the TikTok gurus are all over. Oh, you novate the contract, you get a POA, and then you list the property. Well, the Department of Commerce doesn't agree that that's okay. The Department of Commerce says that agents cannot list properties unless everybody who owns that property's signature is on the bottom of that listing agreement. So let's talk about some best practices, and then we can take questions, because this is not just best practices about this disclosure law. I think everybody's real clear on what you have to do here, right? You got to get that disclosure signed before you enter into a purchase agreement that you intend to assign. End of story. You got that? Yes? Let's just talk about good practices, okay? Because again, the reason we didn't have these laws 20 years ago is that we weren't being encouraged to abuse people 20 years ago. We weren't being taught that it's okay to do some stuff that people are being taught that it's okay to do now. First thing is disclose early, disclose separately. Second thing is nothing that implies any representation. No words should come out of your mouth that imply anything other than you and I are on opposite sides of the table here. I am trying to negotiate the best price and terms for me. You are trying to negotiate the best price and terms for you. Know your freaking numbers. Like one of the reasons for the big explosion in consumer complaints is wholesalers. We should have a different term for these people, but for lack of a better one, we will call them wholesalers, who think it's okay to put 20 properties under contract and not close any of them. And I know people are teaching you that. They're saying things like, hey, just, if you can't get the seller down to a price that makes sense, then put the property under contract at the lowest price you can. And then you can just throw it out there and see if there's any buyers for it. And if there's not, fine, what have you got to lose? And if you do, great, you make money. And if you put 100 contracts a month under contract like that, you'll make plenty of money because you'll close 5 of them. There are real victims on the other side of that, ladies and gentlemen. It's your sellers who thought their houses were sold and they're not. I think as often as not, wholesalers who put properties under contract and can't sell them because they never learned how to do numbers. They don't know what the property's worth fixed up. They don't know what it costs to fix the property. Therefore, they do not know what to offer to a seller. And if they don't know what to offer to the seller, the chances somebody's a bigger fool than they are and is going to buy the deal are very slim. You really have to learn this, guys. There is not a business in the world where you can get rich without understanding stuff. And this is like the basic stuff you have to understand to be a successful wholesaler. Just by the way, we are considering, REIA and COREIA and a couple of other groups are considering putting on like an 8-week serious online wholesale class later on in the year. And I know a lot of your names. I know a lot of you are already wholesalers, but if you would attend that class, if it were, say, $500 or less, can you just say I'd attend in the chat? Because that's gonna take some serious putting together, and I don't want to do it if nobody actually wants to learn how to know their numbers or use the correct contracts or negotiate right or find the right sellers or any of that stuff. Don't list deals you don't own. That is really making the Department of Commerce very upset. And there's no reason to list wholesale deals. If you have a good buyer's list, you can sell any good deal in 2 days with 3 phone calls. You don't need to put it in the MLS. Oh, but I can make $10,000 more dollars. Okay, then close it and then put it in MLS. Nothing wrong with closing it and then putting it in MLS. Keep open the lines of communication with your sellers. Do not ghost them. I talk to your ghosted sellers all the time. They are so angry. Like the first question they ask is, "Hey, are you a wholesaler? Because I don't want to work with any other wholesalers." Well, okay, why is that? Because some guy put my property under contract 10 weeks ago and we were supposed to close 4 weeks ago and he won't call me back. And I just think all wholesalers are scumbags. Well, okay, you put it under contract for the wrong price. You have now realized that. Go back and talk to your seller and say, "Hey, I screwed up. I'm going to need to void the contract or renegotiate it at this lower price. Please accept my apologies. And also anything I can do to help you, I will be happy to do." Don't surprise or blindside sellers with, "Oh, can't close. Oh, need to reduce the price by $50,000. I have had to reduce prices with sellers after I told them what I could pay them, but it's always 100% of the time been because I discovered something in inspection that truly was invisible until the inspection was done, like, broken sewer lines, things like that. And they kind of knew about it. That if they've been living in a house with a broken sewer line, they kind of knew about it and didn't tell me. And so when I say, "Listen, it turns out you got a broken sewer line, I'm gonna have to either give you 20,000 less than what we talked about, or we're gonna have to tear up this contract," they're like, "Yeah, okay." But I don't blindside them with, for no reason other than I don't want to pay what I said I was going to pay. I need to pay $50,000 less. Don't say you've got a property for sale when you have a contract for sale. If you're an agent and you are working with a wholesaler, make sure that you know you're working with a wholesaler. Like, don't list properties just on somebody's signature. Make sure that the ownership of the property is the owner of the property is the same person whose name is at the bottom of your contract. If you're an agent, educate your buyers who are trying to buy from wholesalers, and don't facilitate unlicensed activity. Now, here's the thing. I said there's like three kinds of people who need to be on this call: wholesalers, agents who work with wholesalers, and buyers of wholesalers. What do the buyers care? Well, I've bought some wholesale deals over the years from wholesalers, and generally by the time we get to the closing, I have some actual money up. I've ordered a title search that I'm now going to need to pay for. I maybe have paid for an inspection. I maybe have um, had a contractor go over and give me a bid. I may have paid for that. And if there's any earnest money up, probably I'm the one who put it up. My experience is most wholesalers don't have earnest money. So when $1,000 is demanded of them, what they do is they go find a buyer and the buyer puts up the earnest money. So do you see why from now on, if anybody offers me a wholesale deal in the state of Ohio, I'm going to say, can I see your disclosure? I need to know that you did that disclosure with your seller because I don't want to be 28 days into this contract and with earnest money up and having spent money and have that seller cancel the contract because you didn't do your disclosure. I can't afford to have your mistakes cost me money. So buyers, if you're a wholesale buyer, ask about the disclosure early on. Make sure your earnest money is protected. Understand the risk if you decide to go ahead and accept a contract assignment for somebody who did not do the disclosure, and understand when it's better for you to just walk away. Just say, hey, I am not willing to take on the risk of you not having done what you were supposed to do. So what does this law really mean? It means wholesaling's still legal in Ohio. When the law first passed, I saw a lot of things on Facebook and other social media things saying, oh man, they made wholesaling illegal in Ohio. No, they did not. They just made disclosure mandatory. Your safest strategy is transparency early and often. And trust me when I say complying with this law is a lot cheaper and easier than having it enforced against you. So just remember, ladies and gentlemen, that the safest wholesalers are not the clever ones, not the ones who figure out how to get around this and get around that. The safest wholesalers and the most profitable ones are the ones who are most ethical, who treat sellers and buyers right, who take the business seriously enough to get educated, and who are the clearest in terms of setting expectations of all the folks around them. Okay, so we've got some dates to share here, but first I want to answer questions because I have got to get off of this call in about 15 minutes because, believe it or not, I have another Zoom meeting tonight, as do many of you, at 7:30. Alberto, what's your question?
Oh,
Alberto
hi.
Gonzalez.
Yes, I couldn't unmute. Well, so double closing would be a solution. Of course, disclosure is always good. What about if you create an LLC and then you transfer the LLC at closing to the buyer?
Okay, that is a much longer discussion. That is something that if we did a wholesale class, we would talk about that because there is obviously the argument that I didn't assign a purchase contract. I assigned the entity that owns the purchase contract.
Correct.
I don't think that's going to pass the sniff test with the Attorney General's office because they were very, very clear about we are after making sure that the disclosure gets done and therefore the consumer is protected from ignorance about what's going on. And it's kind of still the same thing that's going on. So I would say, I guess the way I would challenge you, Alberto, is to say, what about this disclosure is so scary that you would go to all that length to create new LLCs, assign those LLCs? Why not just do the disclosure? I mean, there were other ways. There are other reasons to do what you're talking about doing, but I don't think not having to sign the disclosure is one of them.
Yeah, I agree. The thing is that, for example, the way I do it, it is that sometimes you have partner and you're not like a wholesaling to looking for a buyer, and you just create partnership and you have to create another entity, but in the you are in the deal itself.
Okay, that's a completely different reason to do what you're saying to do,
Hmm.
but I would probably still do the disclosure.
Okay.
Okay. Evan said if a contract was signed prior to March 2nd but closed after March 2nd, is that covered by the new law? I'm pretty sure you're okay if the contract, because there was no requirement that you get a disclosure if you sign the contract today, but then it closed March 3rd. I think you're okay. Evan, was that your only question?
Sorry, it took me a second to turn that on. The only other thing that I had that answers that question. What about the deal with working with a realtor? This one was listed on the MLS. There's an out-of-state wholesaler who is in cooperation with a realtor,
Mhm.
and it was disclosed on the contract, not on an extra statement, but on the contract that the whole deal. So
Mhm.
there was some disclosure. It just wasn't on its own paper.
Yeah, but that disclosure was to you as the buyer, wasn't it? It
No,
wasn't to the seller.
that was on the contract
Okay.
that I have already received a copy of that is between the seller and the wholesaler.
This new law is very specific that it cannot be incorporated into the contract. It has to be a separate
that I
freestanding
understand. I'm just
disclosure.
making sure that I'm not in any trouble with this one that's
You're
prior
not-
to.
Yeah, you're not in any trouble because it's not March 2nd yet.
Okay, I just wanted to make sure that, but you're telling me that structure will be okay as long as they have a second, the proper form, or that structure is actually going to be a problem?
That structure is going to be a problem.
That's what I thought. Okay.
Yep. Yes,
Because
sir.
I need to let this guy know that I'm not gonna, because this is the second one I've bought from him, and I'm gonna have to let him know that I can't do it again.
Yes, send him the disclosure. Say this is that
Yep.
we're giving you here. Say this is what I and every other buyer are going to need signed after March the 2nd.
Well,
Well,
I was more getting into the working with a realtor and the issues with how that appears on the other end.
Well, Vena, there's another problem with this too, because he's actually saying that the realtor is listing the contract and not listing the house.
He's listing the house on the MLS, but when you contact them, they actually sell you the contract.
Yeah, so that's really the going to be the agent's issue to deal with.
Okay.
It's like they're the ones who are potentially violating license law by doing what they did. Now, I could make arguments all day long about it doesn't actually say in a lot of MLS rules that you can't list a contract. But the Department of Commerce was loud about that. They do not like that.
I just need to do a little bit more research because I've got good deals from him. I've been happy with them, but I just want to make sure I don't
straight to you
cause
from
trouble.
now on. Don't say don't listen. The Department of Commerce doesn't like it. Just come straight to me.
Okay.
Kevin and then Jose.
Hi, everybody. Vina, my question is this. I actually have a investment disclosure agreement that I've been using since 2012 that says that I intend to make a profit on this transaction. And it doesn't specifically say I'm going to assign the contract or wholesale the contract or any of that language. It says that I'm an investor. I'm going to make a profit on this deal, and I'm going to sell your property for more than what we're under contract. My question is this. Is something like that okay? Do I need to tweak it, or is there a standard form that as members of OREIA or OREIA that's going to be available for us to either download or use that's going to
Matt, can you repost
CMA or CYA or cover our asses all the way around the block Or do we
Matt,
need
can
to
you
kind of come up
repost
with
that?
our own thing?
Nope. Matt's going to post the exact form in the exact words. You can still use your form, but you have to use this one as well.
Okay.
I feel like your form actually goes, in some ways, goes a little bit further than this one, but it's missing some of the language that you need to comply with this new law.
Okay.
Okay,
Thank you. Thank you.
Jose.
Okay, thank you. Vina, I need clarification around double closing in relation to your intent or wholesale's intent. That's one I'm not clear on.
Okay.
I feel that there's like a gray area there and it's not a clear
Yeah,
cut.
and intent is a weird thing, right?
Mhm.
So if I am advertising to you that I will have I will have a property that you can buy on February 28th, because right now I only have it under contract. You can't buy it from me right now because I only have it under contract. But once I close it on February 28th, I would be very happy for you to buy it for $100,000. I think it's very clear that my intent is close it and sell it to you, even if I'm telling you about it ahead of time.
So do we require the disclosure? That's what I'm confused at.
If you intend to and then do close the property and resell it, it appears that this law does not apply to you because it specifically says with intent to assign in the law.
Mhm. Okay, I think that makes things a little clearer.
Well,
Yeah.
where I'll tell you where this is gonna trip us up
Mhm.
is the Department of Commerce doesn't like you saying I have a property for sale if you don't own the property, even if you are going to own the property.
That I understand.
Right?
Mhm.
They don't like you saying, hey, 123 Easy Street's going to be available on 28th because that's my closing date and it's a
Yes.
cool deal and you should buy it.
Yes, I'm clear on that one. Yeah.
So,
And hey, Vina, I'll
uh-huh.
add something. So I was on a jury duty, and we had to decide if a young lady uh was was guilty of attempted murder. So what is the it was what was the intent? Well, the way the law reads, and that isn't in this law, but I think the same kind of thing applies, is that the deal was that if your actions would produce that result, then that's intent. Because like Vena said, you can't look into my mind and know what my intent is. So they have done, at least in criminal cases, where if your actions would result in that. If I point a gun at Vena, I just meant to injure her, but that likely could kill her by shooting her. That isn't attempted murder, even if though I only wanted to hit her arm.
And all of these people would avenge me. You know that, right?
Yes.
Everybody on this call
I know. That's why
would
I would
come and
never do
get
it.
you.
But besides that, we love you.
Okay, so yeah, I mean, again, not legal advice here, but double closing is either I'm going to buy it and then at my leisure I'm going to put it in MLS and I'm going to try and get the top price for it and the realtor's not going to have any problem listing it because I am in fact the owner, or double closing like I'm going to borrow some transactional funds for a day so that I can close it for long enough for my buyer to buy, who I've already lined up to buy it. One of those things is going to be super clean. I mean, I might have mentioned it to people, but I haven't even really made an effort to sell it before I closed it. Like there's no disclosure requirement there. The other one where I kind of have to tell people about it before I close it, but I need to be careful about what my wording is because I don't have a contract for assignment. I have a property that will be for sale, assuming that my seller closes with me like they are supposed to, which is how I've always put it. Like I don't sign assignment agreements with those buyers. I sign purchase agreements, and the purchase agreement says that my requirement to sell to them is contingent upon my seller selling to me. And that if my seller can't give me clear title or backs out or whatever, I don't have to sell it to them. There was a question in the chat at 6:53 from Edward. Does this law apply to all wholesalers residing in Ohio doing business either in or out of Ohio? No, I think it's the other way around. I think it applies to anybody who is doing wholesaling of a property within Ohio, no matter where they live. It doesn't actually matter where the wholesaler lives, which is going to be really fun for the out-of-state wholesalers who aren't paying attention. Shell, what's your question?
I just wanted to thank you for your presentation tonight. And I wanted to ask, do you think that it sounds like wholesaling is like save the date, like you're preparing for a, a wedding or you're preparing for whatever. It's like save the date, whereas the double close sounds like, okay, we know that it's going to happen within this time and this time.
It depends on it depends on how you run your business. Like I have never failed to close a wholesale deal that I put under contract unless there turned out to be an unsolvable title problem, or again, one of those invisible, okay, hey, now that I'm actually going back and doing the real inspection, I noticed that there's a water line 1 foot up your basement wall all the way around. Is there a problem with your sewer? That sort of thing. And as a result, like when I tell a buyer, you can buy this for this much money, they can, because we close, right? It's gonna close. I've done my research. I've done my title search. I'm in constant contact with my sellers. So it's not a save the date. It's if you don't have the money, don't put this under contract because we are closing. Right?
Okay. Yeah. And do you think it's going to be nationwide or just in?
Oh, no. The rest of the nation is getting laws that say you have to have a real estate license to wholesale. There's two states that have a disclosure law instead of a license law, us and Texas. And the reason that we have one is because as soon as this came up, we went, hey, let's look at the Texas law, legislators. They solved the problem without making it so complicated for people to be wholesalers, because it is not cheap or easy to get a real estate license. And we made the argument really early on in testimony that this has been a really good traditional way for new investors to get into the business and start, getting young people, poor people to get the money to like invest in passive income stuff, and to take it away from them by saying, oh no, you have to have a real estate license, there's no need for that. We just need to do this disclosure. Okay, so unfortunately, I am out of time. I've got to go jump on this other Zoom call. I really appreciate you guys coming. Deborah, if you want to go over the save the date stuff,
I'd be happy to.
For everybody, I'm gonna log out, and if y'all have any like really pressing questions for me that didn't get answered, you can send them to askvena@gmail.com. But you might, if you came in late, you might want to wait for the recording of this because it might have gotten answered.
Vena, are the slides also going to be available with the recording? That
Yes.
is a popular question. Okay.
Yes.
Okay. Thank you very much for your time tonight.
All right. Bye, y'all.
All right. So she is logging off and took her slides with her. But if I recall the save the dates, one of them is our Day at the Capitol event that is coming up May 19th. We would love to see you all there. That is where we start a lot of this legislative advocacy. So more information will come out for that, but we would love to have you join us in Columbus. The other one is the fourth Wednesday of the month, our summit open Zoom that you can come and ask questions. Our Summit Night Help Night. Please make sure you log on to that. It's a great way. There's usually not a set topic. It's a great way if you're getting stuck in anything that you're doing in your business. You can come in there. You have 50 to 100 people who will just help brainstorm and walk you through whatever problem you might be stuck on. And then Matt, correct me if I'm wrong, probably the last one was the National Summit coming up next November, unless there was a different save the date. Is he still on? Okay, we're going to call that done. Thank you all very, very much. We will get the recordings and the slides and a another downloadable copy of the disclosure out to you guys, hopefully by the end of this week. If you all have any questions, you can reach out to us at OREIA or Vena, and hopefully the goal is make your sellers happy and stay with this disclosure, and you'll stay out of trouble. That's really what we're looking for and what the legislators are looking for. So thank you all for your time tonight. Have a great night.